from the law firm of Shihab Burke. Sam Shihab, and with me, Brian Burke. We're going to talk today about the $100,000 H-1B fee that was presented or proposed by the president in his proclamation for all new H-1Bs, I think after September 21st, midnight.
After September 21st, and there's a couple things in there, and how that's actually going to play out is really kind of up in the air still a little bit.
Yeah, narrowed down, but a bit. I mean, clearly.
Yeah,
yes,
I think there's still some
absolutely.
edge cases. Yeah.
Quick introduction about us. We are immigration attorneys in the Dublin, Ohio area. We practice immigration law throughout the U.S. and really throughout the world. We have clients everywhere. And we also do a family immigration as well. We've been in the business for quite some time. And we spend about 30 minutes every Monday at 6 o'clock Eastern time to discuss an issue of interest today, the $100,000 H-1B fee discussion. Quick update on that regard. Today, Brian, December 8th is the deadline that the Chamber of Commerce of the U.S. versus DHS deadline to have all pleadings, all motions, all arguments for the judge to look at it. So step back for a second. There are two cases that were filed, one in DC, one in California. The one in California took a standard track in terms of timeline, which means typically a case like this takes a year or so to resolve.
Yeah.
The one in DC, the judge ordered an accelerated schedule and decided to move this case quickly and denied every motion that was presented before the court to delay or get a time extension on anything. The most recent of which a week ago for the government to file an extension of supplementing the administrative record. And the court said, no, you got a December 5th deadline. You got to comply with the December 5th deadline. They complied. Today, the judge gave everybody a deadline. I've seen one filing today that I took a look at it quickly, but the day's not over at 6 p.m. And I'm sure there's a couple of these filings are being held for the last minute, just in case things happen that they have to modify.
A bunch of things pre-written by people just to be submitted, just in case the other side submits something.
So that's all going to happen. So by midnight, all will be done. It will be all electronically uploaded, and all arguments are uploaded, which means the judge could make a decision, Brian, on this before the end of the year. And that is excellent news for those who are concerned about it, because all scholars that looked at this issue believe that the $100,000 payment is not legal. It's illegal.
Okay.
The scholars do not decide. The judge decides.
A judge is a legal scholar, but continue.
Yes, he decides. Yeah. So there are major grounds, and there's a big issue, Brian, that deals with the question of whether or not the judge, one, is going to rule without granting hearing, which means he'll come out quickly. He may say, I've had enough. It's a question of law. These are legal questions. You've briefed the questions. I don't need hearings. I'm ready.
Like oral hearings?
Oral arguments. Yeah. And that can stretch things out into next year.
Sure.
And if the judge says, I'm done, I have enough to make my decision, that will help. And people think, some scholars think that this could happen. So very interesting. All of us are nervous because obviously we believe that this proclamation is not a legal proclamation. And the arguments, Brian, on this is really simple.
That's what I want to hear.
Yeah, the arguments are simple. The straightforward one, which the court most likely will hang their hat on, is the violation of the Administrative Procedure Act, APA. And this is highly technical. I'm going to simplify this. Basically, you cannot implement a law in this country without going through a process called rulemaking. Basically, you publish what you're going to implement. Congress said this. Here's how we're going to do it, and give people 30 to 60-day opportunity to have input, and then they finalize it. That's called process and rulemaking, and that's required for any law. So that was skipped in this process, and the plaintiff, which is the American Auto Union, they joined
Mhm.
the complaint. So there are two big plaintiffs now: the American Auto Union, big plaintiff; the U.S. Chamber of Commerce, I think over 30,000 members.
Yeah.
Uh, Big plaintiff. These are traditionally Republican, at least the U.S. Commerce Republican organization traditionally. So that's a good thing. So the first argument is violation of the Administrative Procedure Act. You have to go through this process.
You put out the payment, the $100,000 payment, without telling us it was coming, without going through the right process, without giving anybody the opportunity to
Input.
comment on it. Yeah, input on it. No notice and comment rulemaking.
Yeah.
There you go. Okay.
The government response on this, and I just took a look at the government response 10 minutes ago because I've had problem accessing it until recently, although it was live 2 days ago. The government argument is, when somebody, a good lawyer who can argue very well, is in trouble because they're spending a lot of time on minor technicality. We did not receive an email that's called out in the regulations, or we did not get a phone call from opposing counsel before they did this.
Yeah.
You don't waste ink on arguments like this unless you feel that you really are narrow. You don't have options. You know what I mean?
Well, yeah, it's old saying, if you have the law, argue the law. If you don't have the law, argue the facts. If you don't have the facts, you get out your magnifying glass and start looking for needles in the haystack, I guess, right?
And the needles are the response started with these fine arguments. Be
Yeah.
that as it may, they're saying that the president does not need to go through the APA to implement.
Is this
But
part of it being part of the foreign affairs power, of the
the foreign affairs power is what the government is arguing, that because it is part of it, you don't need to go through the Administrative Procedure Act.
It all relates to, like, issuing visas, admitting people to the United States.
Yeah.
It's national security, executive power. I execute the laws. This is a matter of being handled outside the United States.
Yes, but it is not handled outside. And this is the argument. The second argument made by the plaintiff is that the president has the ability to restrict access. They can say, well, I cannot let these people for national security, or I cannot let these people come in the United States, as long as it's not discriminatory,
Mhm.
because of good government, for a good purpose.
Yeah.
But that's the entry restriction power the president has.
Yeah. I control
But
the
he
consulates. I
cannot.
control
But
who
that's
gets
a
visas,
huge
I control
difference.
who enters. Yeah.
It's a huge difference from saying you can come in if you pay me 100,000.
Yeah.
And they're saying now, not only that, who's paying it? The American companies,
Yeah.
not the foreign worker.
So to be clear, I mean, even though it's couched in terms of foreign affairs power, overseas, it's overseas. This is through the consulate. This is about people getting admitted to the country. The fee is paid by U.S. employers in the United States in American dollars, along with your H-1B petition.
And there's no access restriction.
Yeah.
Pay me 100,000, you're welcome. You don't
Yeah.
pay 100,000, I don't want to let you in. So,
Yeah.
so it is not a restriction on access. It's a shake down somebody to pay money, to come in.
Effectively kind of sidestepping the entire, properly done, written by law, regulated with rules H-1B program as it is, by just sort of saying, oh, but I have something better than that. Adios, effective H-1B
Yes.
program. Yeah.
There's a law also that Congress passed that says USCIS filing fee has to commensurate with the agency's cost to render the service.
Mhm.
So they're saying, where's that $100,000 coming from?
Yeah.
If that, that it does not follow. So there's strong, solid argument. And then there's a whole slew of other, small business. There's a small business test that you have to do whenever you pass a law.
Oh yeah,
Is the small business impacted?
impact? Yeah, no. If you've ever read a USCIS form, I think it's form instructions, maybe it's a regulation or just any regulation ever. There's a small business administration impact statement.
They pay most of the taxes.
Yeah.
They provide most of the employment.
Yeah.
So whenever we pass a law, we make sure that the small business is protected. Well,
Yeah.
this law, clearly the small business is directly impacted.
Yeah.
Only the big businesses can afford the 100,000. So that's another one here, and so on and so forth. So the argument in opposition are very solid, very strong.
Well,
And all what the president's saying through his attorneys, which is the Justice Department, is
Yeah.
that I can pass a proclamation, and it's my entry power, and I'm exercising my entry power. But that's not enough, in my opinion,
Yeah.
to win the day for them. So
Well-
I'm optimistic that this thing is going to get shut down, and very likely by next week, by before the end of the year.
and yeah, probably sooner rather than later, because judges like their holidays as well.
And I will leave, and I've gone more than I'm supposed to, but I will leave one question here uh, up in the air, which is very interesting, is whether or not the judge is going to issue a limited. If they do issue a positive, is that going to be a limited ruling for the U.S. Chamber and the American Auto Union members, which is a very limited, or is he going to issue a nationwide injunction? A nationwide injunction has been limited significantly by the Supreme Court, but there is a within the Administrative Procedure Act. There's something called the vacator.
Mhm.
Vacator is a mechanism by which a judge can invalidate a law through the APA and has a nationwide effect. And
Yeah.
people think that that is probably the simplest route the judge can take to have a nationwide impact without calling it a nationwide injunction.
Yeah, that's a very fun thing because as we got from the birthright citizenship case, basically the Supreme Court made a decision that said, all these, from small little courts in the middle of nowhere, those nationwide injunctions, we don't want those anymore. So they have to look for other avenues. Yeah.
And a side note, the DC court is the only one that still believe that they will do that because immigration has a national impact.
Mhm.
You cannot have, how does the State Department figure out how to issue visa, not issue visa, who to let on the border, not to let at the U.S. border? So so there's a
Well,
lot of reason to provide a nationwide
yeah,
injunction and get
because
a
because I
favorable
was thinking
decision.
about this from another perspective, just the practicality of having, this only applies to members of the automotive union and the Chamber of Commerce, because suddenly USCIS has the massive job of evaluating of are you actually a good member in good standing
Oh,
of
it's a
the
nightmare.
yeah.
Well, but the Supreme Court had no problem with the birthright to create a chaos.
You're a citizen in Ohio, you're not a citizen
Oh,
in
it's chaos.
Alabama.
So
Yeah, yeah.
so the APA vacator
Hmm.
mechanism that's within the APA
Hmm.
is an easy way for the judge to have a nationwide implementation without calling it a nationwide
Yeah.
injunction. So that's what we got today. So I'm looking forward. Today is the last day they can file anything in the next few hours, and then the judge has time to sit down, think about it, and decide whether to rule or to call for an oral hearing, which will then drag this out a
Yeah.
little bit longer.
Yeah. Well, fair enough. I mean, one thing we should all remember is this proclamation only goes through September 21st next year. A long track case is one that will eventually be rendered moot. But Sam, there's other things to talk about because boy golly gosh, is it a cornucopia of immigration news lately? And I wanted to hit a couple of them here. One, if anybody got a 5-year EAD adjustment EAD from USCIS recently, well, say thanks to somebody because the next person in line is probably not going to get one of those because USCIS just updated their policy to say that tons of categories that were getting 5-year EADs, most prominently people with pending adjustment of status, are only going to get 18-month EADs anymore. So obviously, those EADs, I mean, they're giving those EADs at for about 2 years, those 5-year EADs, maybe a year and a half, maybe 2 years. So there's a lot of those out there. A lot of people don't have to, won't have to apply again, but the new normal is 18-month EADs for
As
USCIS.
as a matter of fact, the new normal is 1 year, Brian, and the 18 months is extended. So like asylees and all these
Yeah.
people got 1 year.
Yeah. Yeah.
The adjustment of status were lucky enough to get 18 months.
Yeah.
So yeah, I mean, hey, the message from the administration: we want to vet people more often. We want to see within 1 year if you were a saint and you became a devil.
Yeah.
Um,
Their
so
logic was
we
basically
want to
we're
know what's going on.
and we were talking about this earlier today. 5 years is a long time, and they said they
It's a
want to
long
vet
time.
people more than every 5 years. And
I
I,
agree.
I got to understand that. 18
Yeah,
months, I'd say maybe I would have liked two
it's too
years out of
tight.
it,
Yeah, I
but
agree.
I understand why they're
18 months is too short. 5 years is too long. And but in fairness, 18 months may be closer to the reasonable timeline than the 5 years.
yeah.
Just to be
Um,
fair.
Yeah, on a sort of related note, just as a reminder for everybody, because it's sort of a good thing to dovetail off the shortened EAD approval period, is just a reminder: automatic extension of EADs is, for the most part, over. There's certain categories that allow it anymore, but popular automatic EAD extension categories like pending adjustment or H4 EADs, they're not entitled to automatic extensions anymore. That policy has not even policy; that's a regulation that's been withdrawn,
As
and
as of October 30th.
yeah,
And the only one that's effective is F1 student because
yeah,
it's a different law.
yeah,
And for L2, Brian, so people are
yeah.
reminded,
Yeah,
if you do not have an L2S,
yeah,
I-94,
yeah,
you need an EAD.
yeah.
And if you don't have an E2S,
Yes, you need an
you
EAD.
need an EAD, and those people do not have an automatic extension.
Yeah,
So just a reminder, yeah,
yeah.
absolutely. But
And if I'm gonna, yes, go
yeah,
ahead.
please, yeah, and that's
Well,
it.
I
Yeah,
want
go
to
ahead.
hit sort of the end of our immigration, news roundup here. There's sort of a pretty big and developing one here. It's the travel. Well, it's the I guess it's an application stoppage and a travel ban. So maybe middle of last week, we got an update saying that people from 19 countries that are already on this travel ban list that was from what June, I think it was, they're going to have all their applications stopped. And this is sort of people from those countries across the board. We had one of our attorney Joe in our office was going to an interview. I think it was on Wednesday last week. He had a client who held sort of dual citizenship of one of those countries as well as another country, like a European country. And that interview was canceled for him. They went down and kind of left empty handed without an interview. But this is going to be across the board. It's going to be people who are from those countries on employment immigration, family immigration. There's that.
Brian, people the naturalization ceremonies
Pluck that.
were
Yeah.
canceled
Yeah. Plucked out a line. They were close.
because that one I don't understand how can that be canceled because that one is
They've
only
already been vetted.
ceremonial.
Yeah,
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 only
that's right.
ceremonial.
I mean, Sam,
Yeah.
I spent my entire last week. I had a gentleman who just got his, excuse me, visa from his wife from a travel ban country, and excuse me, Sam.
As Brian coughs and clears his throat, let's go in on and talk about the State Department announcement that as of December, now you have to turn your social media handle to public if you're applying for a visa. So that's also
Yeah,
a new development. So that is something that the State Department, I think, a while back announced it. Now it's implemented. To go in, you have to turn your social media handle. If you have a private one, it needs to be turned to public. And then we got a travel ban expansion. I'm trying to get to some questions before the end
yeah,
of the day. We got a travel ban expansion potential that you were just telling me about, Brian,
yeah.
that expanding the travel ban from 19 countries to up to 30 countries. That's
Over 30
coming within
countries. Over 30
over
countries.
30 countries. That's coming within the next couple of days.
Yeah, I mean, basically, when this first travel ban was announced, we heard it was as high as like 40 some countries, and then it only came out, in terms in 19, and I guess this is sort of, phase two of that. And we kind of got the impression, especially from the nature of the travel ban, there are certain countries that were being watched by certain statistics like visa overstays and that sort of thing. And I guess, they're now ready to act upon that, essentially say, we gave those countries a chance. They did not clean up their acts, and
Yeah.
that is that.
Yeah.
So, Sam, shall we segue to some questions?
Yeah, please.
Okay. Well, let me pull them up here, and I didn't have the opportunity to get them all in, but I'm going to get some of them up here. And always, folks, don't hesitate to give us your questions live because we do take them live here. But what I'm going to do is pull some of our questions from immigrationquestions.us, which that's the .us domain, and that's our fun little website that says, hey, send us a question and we'll hit it here live in YouTube. And if we can't hit it live in YouTube, we will get it via email. And there is the first one. And it's a good classic H-1B related question, Sam. I'll go ahead and read it. Maybe you'll answer it. My employer allows for 8 weeks of paid bonding leave, another 4 weeks of unpaid leave. When in H-1B, do I have the option to avail this unpaid leave? And I think maybe it was cut off, but there's is. Can I take advantage of that?
Well, that's a great question. That's an H-1B good question.
Yeah.
So now there's a problem with that. And I think you're not liking my answer. So
I'm going to hear you out.
let's assume the LCA prevailing wage
Mhm.
says you can pay 80,000.
Sure.
Okay. Um, um, and then you're taking unpaid leave, and you're at the end of the year, you ended up being paid 76,000. You were not paid the prevailing wage on the H-1B. So that's one problem I see with that. The second thing with the unpaid leave, unless there is a reason for your unpaid leave, for example, pregnancy, sickness, beyond the paid leave, um, an unpaid leave is a fancy word for what the H-1B world calls benching, and benching is not allowed. Now you can take vacation, you can take unpaid leave and leave the U.S., and at least there's very, very weak opinion that that's not permissible. I don't buy that. You
No,
can
no,
take your
no,
unpaid leave and leave the U.S.
no.
You can leave it, but you cannot take unpaid leave and stay in the U.S. because that you're on H-1B. Brian,
Okay.
give me your counter.
I'm going to give you a regulation. There's a regulation that talks about this. What about like FML? There's a regulation. I'm just going to see if I can find it. H-1B unpaid leave FMLA. There's a regulation on this.
Family
This.
Leave Act. So two things on that. Let me address the Family Leave Act. Number one,
Okay.
The Family Leave Act is applicable for employees of 50 or more,
Mhm,
not less than 50 employees. Just
mhm.
kind of that's not really very
Okay.
relevant, but good information.
Okay.
The second thing about the Family Leave Act, Brian, is
Mm,
the Family Leave Act. What it does, it doesn't say you're allowed to go on an unpaid leave. It says you're allowed to get your job back after being on unpaid leave for a sickness or a personal reason.
okay.
The Family Leave Act was not written for H-1B visa holder, although it's if applicable. I mean, the H-1B holder are included, but the thought behind it, you're
Well,
about, you want to say something? Go ahead.
well, I don't can't find the regulation, but I can find the DOL fact sheet on the subject, and those are
Okay.
pretty good.
Yeah.
So, must an employer pay for non-productive time, H-1B. And basically, they say no payment is required under the H-1B program for non-productive time due to reasons not related to employment, such as a worker's voluntary absence from work or hospitalization, etc. Employers, however, remain obligated to comply with the INA or any other statute relating to employment, such as the FMLA. So I'm pretty sure they explicitly list like pregnancy leave, maternity leave in the
Yeah,
regulations.
sickness is okay, Brian.
Okay.
Anything related to sickness is okay. But hey, I'm just super healthy. I'm just taking 4 weeks off, staying at home watching TV and not getting paid.
Well,
That's not acceptable. The Family Leave Act doesn't support that. H-1B law doesn't support that. That's called benching. Now, I'm sick, and and my employer allows me to, and the Family Leave Act support that. What the Family Leave Act doesn't say you're entitled to, but what the Family Leave Act says that you should give somebody a leave for their sickness, and up to 8 or 9 months or some 10 week, I forget the date.
yeah, yeah,
They're
yeah.
guaranteed their job back. It
Mhm.
guarantees their job back. Okay, it
Mhm.
doesn't say anything else on that. And then
Well,
not only
I
that,
mean,
but
the FMLA law is not going to talk about your compliance with H-1B status. So
yeah, yeah,
you're viewing this from a perspective of you should, if you're on H-1B status, you're supposed to be in H-1B employment and engaging in a specialty occupation because that's what the law says of H-1B. But
yeah.
I'm going to bump up
I
again.
have no problem with taking time off. I have a
Yeah.
problem with taking time off unpaid. I have no problem. Take the time off. You have we have a policy of 2 months vacation. We
Mhm,
have a policy of 3 months vacation.
mhm.
It applies to everybody in the
Sure.
company.
Sure.
Everybody gets it.
Mm.
Yeah,
Well,
sure.
I will.
But hey,
Here's what.
you're unpaid. We're not going to pay you. Yeah, take time off. We're not going to. That's called benching, Brian.
Only if it's for the purposes of the employer's benefit. Benching, like, oh, so we can put you on unpaid leave, so we don't have to pay you. Whereas DOL rules, here's what I will agree with you, Sam.
I think okay. So here's the scenario. I'm going to take an unpaid leave.
Yep.
Okay, because of what?
Well, I know where you're going because well, you want to just hang out with your kiddo for an additional 4 weeks.
Okay, how about 6 weeks?
Um, sure,
You
yeah,
know where I'm taking you down the road now.
sure,
Okay, well, for this guy, would like to have 2.5 months.
okay.
I'd like to have 15. I'd like to have. How about 6 months, Brian?
Okay.
Give me an unpaid leave for six
Here's
months.
where I'm gonna get. Here's where I'm gonna get on board the Sam Shihab train of skepticism. And here's where I do agree with it. If you come to USCIS and tell them, "Hey, I've been on unpaid leave for for 6 months for my benefit," they're gonna look at some scrutiny on that. So, for example, I've represented people who've been on maternity leave, unpaid maternity leave, absolutely non-productive, and I have represented that to USCIS as recently the last couple of months I was on a really complicated H-2B scenario. It's basically unpaid leave, cited that regulation. The government has taken it, and but also it was an unpleasant RFE,
So
and the government. Yeah.
this is called paternity leave.
Yes. Agreed.
Okay, and I mean some form of paternity leave is accepted because socially, you have a wife who has a need, you want to be home, the child is born. So I can see that argument that it's a health related and family related, and it has to be reasonably related to an event, but not because I want to go sit down and watch TV. I'm gonna get for. I'm gonna just.
Oh,
I no. My wife is not pregnant. No, we don't have kids. No, I'm not sick. My wife is not sick. Nobody's sick. But I'm gonna be home.
huh.
For
Unpaid leave for bonding. Okay. See, so you're okay. You're
yeah,
reading this.
there.
You're reading this
Yeah.
differently than me, I guess. Maybe
No, no.
8 weeks of
I
paid
think we're
bonding
coming to a
leave.
common ground because I think you're saying that if there's a real. I think what you and I saying,
Yeah.
quite frankly, is if there is a rationale,
Yeah.
there's a rationale, and has to do to health, fitness of the family. There is some flexibility that can be accepted, and I
Yeah.
agree with you on that.
But and they will put a microscope underneath you and you're gonna scrutinize this because again if you
Yeah.
say hey I spent 13 months off for maternity leave or paternity leave I'd
You're
say I hope
100%
you
on
had two
that, by
kids
the
I
way.
hope you had two kids during
Yeah,
that time because there
yeah.
has to be limits somewhere and that's why
And
you're goading me with what about 4 months
100%.
what
No,
about
no,
6 months
I am 100% in agreement with you on that caveat on an unpaid leave in that scenario. Now, what they also look at, and we probably need to move on to ask more questions. We kind of digress into that one, but this is
yeah
a good question.
yeah
What the Department of Labor looks for when you have an unpaid leave is whether or not there has been a switch in assignment, because the moment there is a switch in assignment,
so like a
that
consulting
unpaid leave
scenario
is rejected. But if there is a good, you have to tell them a good reason. Well, I have a maternity leave. I had my grandparents came here to the U.S. and we had to go take him to Disney for a week or two.
I've
I
done
can see that.
I've done that end of assignments well I was pregnant with a kid my assignment ended and I chose to not, to pick up another one at that
I,
time. It's very
I
fact
can
sensitive.
I can guarantee you it'll be a lot tougher to sell.
Well, for sure. So
Yeah.
we have a live question here, Sam,
Yes.
and I think it's a sort of right on point for everything we've been talking about. I'm Canadian with EB3 AOS now, but I was born in one of the 19 countries with immigration restrictions. I'm from half restricted countries. Will my green card status be affected? I got my 5-year EAD.
Well, number one, the I'm assuming I'm assuming your party is not current. I'm assuming to just simplify.
Mhm.
And I honestly believe this vetting is not a long-term thing. At least it's 3 more years.
Well, they were on enhanced vetting for these 19 countries on the list previously, and they kept processing cases for them. But now they've just put a stop on them. Is the difference here?
There's a reasonable time after which I think there'll be mandamus filed in court action.
Yeah, I mean
There's a
yeah,
reasonable
exactly.
time
Yeah,
for national security.
yeah,
But call it 6 months. I'm gonna just call it 6 months.
yeah.
I mean, but after that, you just cannot.
Yeah. I mean, this is kind of the same stuff we're talking about in the lawsuit, the 100,000 H-1B lawsuit. You can't just stop by proclamation stop the laws as they are written. Eventually, it comes to court, and eventually, the court's going to say you can't just never make decisions on these people's cases. You can't just discriminate against these people in the law if they're otherwise eligible. But I'll give my realistic opinion is if you are one of those 19 countries, if this person's party date is current, I would say it is likely that that their case is on hold because
Yeah.
again, we heard this around the country, and anecdotally we've seen in their office somebody who was a citizen of later became a citizen of a non-banned country, but also a citizen born in a banned country. Um, Interview canceled.
This person is lucky. He has 5-year EAD.
Yeah.
And for those who are EADs expiring, I think they are going to be in a tough situation because that EAD ain't going to be renewed
Yeah.
for a little
Well,
while.
and no automatic extension is the fun little
Yeah.
bonus
On top
part
of it.
part of
Yeah,
that. Yeah.
absolutely.
So gonna grab another one of these ones from immigrationquestions.us, and I'm gonna maybe read it here just so we don't have to
Sure.
watch Brian fidget with it. So, hello, sir. I'm on both EB2 and EB3 pending adjustment of status. India priority date January 2014. Hypothetically, if my EB3 is denied, can I can I file EB5 and port my priority date without leaving the country, given that EB2 is pending? Do candidates get any grace period, like 60 days on H1 if AOS is denied? Can I expect my priority date to become current in 2026? Thank you so much. So this is like a Trojan horse of a question, Sam, because there's like at least 4 questions in here.
Yeah. Yes, maybe, possibly, no.
So
I don't know. I mean, any of the above. But okay, let's break it down here quickly
okay,
because
so yeah,
obviously, so on the adjustment, I think there was a question on the adjustment. Let's parse it out. So
Yeah.
one of the question he has is can I file an adjustment of status if I'm not on a status here in the United States? Because
No.
being on an adjustment of status pending, if that's denied,
If you don't have
can
any
I
non-immigrant
hop to a
status,
different
yeah.
adjustment of status? That's one
No.
question.
No. You
Well,
cannot.
subject to 180 days. So within 180 days of being out of status, I need
Okay, INA
45K.
240K. Okay, sure.
Yeah. So you have a window of 180 days. It could be done after that. Once you cross the 180 days, the answer
Yeah.
is no. Good.
Yeah.
So we've
Um,
resolved that part of the question,
yeah.
right?
Can
What's
I
the other
file
part of the question?
the next one?
Yeah.
Can I file EB5 and port my priority date without leaving the country? So you cannot port an EB3 priority date to EB5. They do not.
Okay.
There's no portability amongst that.
Okay.
Let me see
Answer
here.
that one. Yep.
Yeah. Do candidates get a grace period if their AOS is denied? No, they do not. However,
Mm.
when you get an I-45 denial, we don't see them much, but people occasionally bring them to us. They will tell you typically what they're saying right now is your advanced parole, if you had any, is automatically revoked, and your employment authorization, I believe they say expires in 17 days or 14 days, something like that. And that's that.
And they're going to say it's not appealable.
Yep.
However, it could be appealed.
Yeah. I just had a
You
big
can file
success on one of those in like the last 2 weeks. Yeah.
you've already filed a motion to reopen, reconsider.
Yeah.
Now, really, you're into borrowed time.
Yeah.
The government can issue now something called
An
notice to
EA.
appear.
Yeah.
Notice to appear, which put you in the deportation court, which you can fight your fight there as well
Yeah.
if there is an improper denial.
Yeah.
Um, so there's a lot that can be done. This is a very complex question, but yeah.
Yeah.
Anything else?
I think the very last thing is like, can I file EB5? I would say that EB5 is not a fast solution to an immigration problem ever. EB5 is sure is complicated, I guess is the bottom line. I would say on that. A quick and dirty EB5 case is not something that I would wish upon anybody, either you or the poor attorney who has
Has
been
it to meet the deadlines?
retained to do it.
Yeah,
Ask me how I
but
know.
it
You
could
know,
be a clean case.
yeah, yeah. It all
Could be
depends
simple clean case. If
upon
there's
how you
cash in
do
the
it.
bank, simple cash in the bank, and there's a business transaction, one single transaction,
Yeah.
with a good business plan, that can happen quickly.
I would just finally say you can do a transfer of underlying basis from EB3 to EB5, but your EB5 priority date would have to be current. And as discussed earlier, your priority date is not transferable to the EB5 category. They only allow you to use your priority
Mhm.
to retain your date amongst the
Mhm.
first three employment-based
Mhm.
categories. Yeah,
Mhm. Mhm.
yeah.
Okay, good. Well, with that, Brian, we hit the 6:30 mark. Thank you guys for listening to us. We'll be back next week at 6 o'clock and um, talk to you more, unless a judge issues a ruling that's unexpected, which I don't
Well,
think it will
it's
happen
always
that
fair
quick.
game that you might find us here on a Tuesday, Wednesday, Thursday,
Mid
Friday
mid
night with some
midweek,
good
midway.
immigration news, of
Yeah.
course. Yeah.